And I think you heard from testimony last week that even people who don't particularly think that the joint proposal solution is the solution that they would pick, that they also agree the current system is not working. Some of the issues that I heard in the testimony last week from former and current district commissioners was that there's a lack of communication and understanding about how different districts address problems. There was certainly concern about when a district commission decision is appealed that the district commission no longer has a say in what the outcome of that appeal. I heard that from most of the witnesses that since the environmental board was eliminated in 2004, there's a lack of guidance on interpreting Act 250 criteria and policy issues. And we agree with all of those problems exist in the current system. And this whole effort came out of a discussion about the future of Act 250 and modernizing Act 250 for the 21st century in the next 50 years. And from our standpoint, it doesn't make sense to engage in a modernization effort if you're not going to address those problems. And we can have, and the conversation I think we're having is about how best to do that. But the status quo, I don't think, is working for lots of different people who engage in the process. And so, in bringing this joint proposal forward, we're trying to meaningfully address these problems, not just kind of nibble around the edges of the problems. And doing so is hard, right? Because whatever change is made, somebody's not going to be happy. It's going to be really impossible to make everybody happy with, fundamental changes to address what we see as fundamental problems. So, what are some of the, diving more into the specifics of the problems that VNRC has seen, and I personally have seen in my work in Act 250. So, one issue that I've seen and see is that the volunteer district commission process is stressed. As NRB chair, I witnessed firsthand district commissions struggling with the complexity of applications. I witnessed the difficulty in getting qualified people to serve on district commissions. People who, they may be brilliant business people, they may be, great at whatever they do in their life, but it doesn't mean that they know land use, that they have any familiarity with Act 250 or their criteria, and they have the time to invest significant time in working through Act 250 applications. As you heard from other witnesses, we're essentially asking volunteers to review applications for the largest, most complex development projects in Vermont. And when Act 250 was enacted 50 some odd years ago, applications were probably this thick. You didn't have consultants involved with every single application. And that's just not the way it is. And after 50 years of precedent and experience and changes to the law and to science, Act 250 applications will routinely be this high, full of consultant reports, and it's just hard to get these volunteers to be able to have the right experience and the time to invest in these issues. When you get hearings on applications, they involve all those consultants, all that technical information. There are usually attorneys involved now. There's evidence, there's process arguments that the commissioners resolve. And in my opinion, continuing just to ask these essentially volunteers to do all this work is just not sustainable over time. I mean, I think there'll come a time, if nothing is really changed with the process, there'll come a time eventually where there'll be a need to really address this issue, because the system, I think, will, under its own weight, really buckle even more than it has. So I think something needs to be done to address this issue, and the joint proposal addresses them, as you know, by trying to invest in the process, have 3 full-time professionals that are qualified that would sit with regional commissioners and make these decisions, and then the decision, the board, the hybrid board of the professional board members and the regional commissioners, they would have available lawyers from the board staff and technical experts from the board staff. And in our view, that seemed to be a logical and sensible way to maintain regional input into the process, but also make sure that there are qualified people who have the time and will spend the time because they're going to be paid full time, and they'll be able to deal with the complex technical issues and the consultant issues and the legal issues. You know, from our perspective, it was important that we wouldn't have agreed to a proposal that didn't have regional input and that was not a strong independent board. And so we worked hard to ensure, basically based on the work that you did, just taking the language that this committee wrote about the board members being appointed through the judicial nominating process, that you can only remove board members for cause. This would make this board more independent than the environmental board was. Under the old environmental board, the chair could be removed for any reason. It didn't have to be for cause. If the governor didn't like a decision of the chair could be fired. You know, they didn't have to give a reason for firing the chair. The appointment process was not a joint legislative and gubernatorial process the way the judicial nominating process is. It was solely the governor who made those appointments that were confirmed by the Senate, but that was mostly a pro forma process. So, you know, from our perspective, we're weighing this. We see these issues with district commissions and really, is this the right system to review these large, complex projects? You know, remedying that by investing resources into the system, keeping a regional component, and making a strong independent board. And in doing so, in our view, you know, if this is done right, you'd have one strong, independent, fair process. That was the goal. And maybe we didn't achieve that goal, and as I go through my testimony, I'll get to, you know, certainly, you know, the concept could be improved upon, but the idea is to have that one strong, fair, independent process that's sustainable, and you have people who, you know, have qualifications to be involved with the process and the resources to be involved with the process. So that was the goal, and that was a big reason why VNRC supports the proposal. Another problem that VNRC identified that drove us to agree to the change was that the whole system that involves right now the district commission, the NRB, and the court as a system just does not work. And I think you heard that in testimony from a variety of witnesses. I think you've heard that prior to 2004, when we had an environmental board, you had the district commissions, they issued decisions, the appeals went to the environmental board. The district commissions knew that if there was going to be an interpretation of the criteria, it was going to come out in a board appeal. The board could speak strongly with a clear voice about how to interpret the criteria, what the policy should be, and once that decision came down, district commissions understood that. The board then, who administered the program, could talk to the commissioners about that decision, explain what they meant, and really flesh it out. Sometimes then enact guidance to further flesh it out. It was a much simpler process, right? You had the commission and the board, and some things went to the Supreme Court to resolve legal issues, but you know, most things got worked out between the commission and the board. So after 2004, you created a process where you had the district commissions who were independent, making their decisions, right? The applicant goes there, they go through the district commissions. You have the NRB. The NRB can provide advice to the district commissions and support. It is completely within the discretion of the district commission to accept that advice and support. And my experience as the NRB chair and as a participant in the process was that it really varied from district to district about whether they would seek NRB advice and to what extent they would. You know, the district commission could say, we want you to research this issue and give us your opinion. The NRB could say, well, can we go to the hearing? Could we sit with you? Could we help you, you know, deal with evidentiary issues? The commissions almost always said no to that request. They could say yes, and the NRB could ask that that's how it worked. But it's really up to the commission, and that's not how the system works now. So as a result, you really have the commissions independently making their decisions. And then when there's an appeal, as you heard, the commissions are not a party to that appeal, and the commission decisions are not really, it's not the basis of the appeal. It's a de novo appeal. You're hearing everything all over again. The NRB is the party, and the NRB could do what it wants. It doesn't have to talk to the district commissions. It doesn't have to consult with the district commissions. I think it's a good practice to do that. And when I was NRB chair, I did do that. I would not just reverse a district commission decision on appeal without at least talking to the district commission, but I didn't have to do that. under the law. I wasn't directed to do that. I could settle a case in one day. I could direct my attorneys to just go in and just change the decision and take another position. And that's legally how the structure is set out. If the case isn't settled and the NRB is a party, whatever position the NRB takes is arguing to the court. The court doesn't have to listen to the NRB. The court is its own independent entity. So you have the district commission making decision X, the NRB could take position Y and argue that to the court, and then the court could do Z. The court could say, I don't agree with the commission or the board, I'm gonna do my own thing. And the result of this system is that it creates a lot of confusion and about who's making the decisions and what is the policy on Act 250 and who's setting that policy. And as you heard, it creates a lot of tension between the district commissions and the NRB, because no one likes it when their decisions are not adhered to, right? No one likes it when they spend a lot of time, like you heard Jocelyn Wilczek's testimony. I mean, I agree with everything that she said. And there's a lot of tension there, and it's a big part of being NRB chair is managing that tension, because you have to administer the district commissions, but you have this situation where the commissions are not really involved with the appellate decisions, and then the court doesn't have to listen to either the commissions or the board. So the whole system right now, it does not work together well, and we think so. What we proposed is a way to kind of piece it back together. You'd have, a strong board that needs to have meaningful regional input, and then that decision would be a strong decision on Act 250 policy. It would need to be a fair process that was not burdensome to citizens, and that's easy to say, I agree. And if this were to go forward, we need to work hard to make sure that that's exactly how it was implemented. But if we did it right, you could have that one fair process that has a regional input, and then the really big legal issues would go up to the Supreme Court, and it would be a much more cohesive system. So that's the idea. That's VNRC's thought process on why this would solve that problem. So another problem that you've heard about this year and last year is that on its own, the appellate system is not working. So putting aside that the whole system, the parts of the system are not working, just the environmental court system hearing Act 250 is not working. You're going to a superior court to interpret 30 criteria and sub-criteria that are very technical. It's a very expensive process. VNRC has participated in a number of Act 250 appeals under the court system, working with citizen groups. We'll spend tens of thousands of dollars at the district commission, because you still have to bring in your witnesses, you still have to put on your case, you still have to go through the process, and you want to. And then for what gets appealed, you go through it all over again at the court, except it's more expensive. Except you have discovery, you have all depositions, you have interrogatories, and you could spend hundreds of thousands of dollars in the environmental court. So another part of our thinking was that, is there a way to address these problems? Cutting costs in a step does work for applicants, but it also works for nonprofits and citizen groups that are spending lots of money that they don't have. Applicants, at least at the end, if they get their permit and they build their project, they'll make money, right? They could build that into their cost of doing business of their project. It's just lost money for a nonprofit that intervenes or gets involved in Act 250 appeal, and it's certainly money that citizen groups don't have that they have to raise. So again, our thinking is if you can have one good, fair, inclusive system that has regional input, everybody could save money and it would be more efficient. And maybe there's a Venn diagram where everybody benefits from the system. So that is another benefit of the proposal that we saw as we put it together. There are other concerns about the joint proposal, and I'm not going to go through and address them all, but I do just want to say and be clear that there's no question that this whole change from the district commission process, how it works, was the hardest part of the agreement, the joint proposal that the VNRC worked on with the administration. We struggled with all the same issues that you're struggling with, and we struggled with we talked to people who didn't like it because they didn't want to see that change in the district commission structure. They didn't want to lose that part of the process. And we understood that, and we understood those concerns. And I'm not here to tell people those aren't valid concerns and that, and just be dismissive of them. But in the end of the day, it kind of goes back to when we thought about it, working on these issues for a long time. This current system just isn't working on a lot of different levels, and we need to make a change. And we're trying to find a change that could be supported and really go into law. We've worked for probably more than 20 years on trying to expand Act 250 criteria to address issues like forest blocks and habitat, which we haven't been able to get into law. Actually expand jurisdiction in Act 250 responsibly where there are gaps in jurisdiction. We haven't come close to getting anything like that into law. We've seen a diminishment of jurisdiction and exemptions, but we have not. We might get a bill out of a committee. We might get a bill even out of one of the chambers, but we haven't been able to get any of those things into law. And we've had these process concerns all along. And I think what the joint proposal does is create a framework for something that could address these problems, make improvements with criteria, make improvements with jurisdiction, but also do some things that the business community has wanted, like not have jurisdiction in our designated downtowns and neighborhood development areas and things of that nature. And I think the process changes, if done right, could actually address everybody's concerns. So I think what's before you is a proposal that if done right, could allow us to move forward with changes we haven't been able to achieve in Vermont really ever. I mean, we've certainly done things like, had plenty of exemptions, but we haven't sort of had a balanced approach to try to see if we can improve Act 250. And, our conclusion is that if changes are going to be made to Act 250, there's going to need to be it's going to need to have broad support. Now, that doesn't mean that everybody is going to support the proposal, and that nor should they. It means that there's a cross section of people who will see that the system could be beneficial and fair, and that the proposal as a whole is really going to improve Act 250. To that end, I would just urge you not to abandon this proposal right now, or a cornerstone of it, which is this change to the board, commission, court structure. I would urge you. I've been trying to. I've been talking to people from the planning community, from the legal community, from the business community. There are environmental groups, and there's some of that on your calendar for this week, who have not had a chance to testify about this. And I would just urge you to hear from their perspective, because I think you'll see that there are groups out there that do support aspects of it, often with changes. But I just think you should have that information before you just decide just to say, no, we're just going to put that to the side, we're not going to go that way. If after hearing all that, you decide not to go that way, I mean, I think that's obviously fair and completely within your authority, but I just don't think you've heard the full range of information about the proposal. And I want to be really clear that no one's saying that there's an expectation that you just take the proposal and just go with the proposal as it's written. But there's a framework within there, and there are improvements to the proposal. And I believe that VNRC wants to see, if this board, commission, court change goes forward, meaningful regional participation. If that's not in there, I believe the administration is open to changes to try to address that issue. And if people think that the regional input right now is not meaningful enough, well, within that framework, is there a way to improve that? The concerns about citizens being able to have access to a new system like that are totally real, and I have those same concerns. And I agree with that. It's hard to write that into the law. You could write something into the law that says that's the intent, but effectuating that intent is difficult. But I would ask the committee to try to legislate and write something into the law to address those issues rather than just abandoning it, because I know that we share that goal, and I think that everybody shares that same goal. So the question becomes, well, how do we effectuate that and implement that goal? And I think, you know, if you do stay, if you're able to improve the proposal, if you get to the point where you're more comfortable with it, I think it does create a path to sort of addressing all of these issues with Act 250 in a way that could have, you know, broader support. But if you conclude after hearing from other people that you don't feel their issues have been addressed, obviously, you know, I mean, the committee will make its decisions and we'll see what happens. But I just, after last week's testimony, I just felt like there was some sort of gearing up to a conclusion about this, and I just think that I would urge you to hear a little bit more. And I just wanted to kind of share our thinking on how we got here, because I hadn't had an opportunity to do that. So I appreciate you hearing me out, and happy to answer any questions you have, or get up and leave, whatever you guys want me to do.
Thank you, John.
Yeah.
Questions from the committee?
Thank you. This was helpful. My question is, and I appreciate you laying out some of the challenges that you are trying to address and the priority of those challenges to make as you, in your words, a fair and a fair process. What we heard earlier at the end of last week from some of the district commissioners' testimony was the potential consequences for making changes like this. In particular, it may result in a more formal process that might have the opposite effect of creating a more litigious, more formal, and potentially more expensive process. So we, in our efforts to try to be mindful of trying to find that balance, can you address how this proposal may, in fact, address this particular concern?
I mean, yeah, I think so. For the majors that are going to be, you know, people are going to come with lots of consultants and probably lawyers. I think the process is already pretty formal at the district commission. You know, as someone who's participated in those process, you know, you need to come with your lawyers, and yes, the rules of evidence are not strictly implemented, but people still object to testimony, and it still feels like a mini trial. And I think that for those issues, if we did this right, you could have you know, a comprehensive process that would be very much like the one today. It just would have more resources. You'd have the 3 full-time board members who are paid to be there. They'd have more staff at their disposal. Hopefully, some of that staff could be used to help citizens through the process. For the majors, and for that, you know, I know you know this as the committee because you've heard this. That just means that there's a hearing. So there are majors, things that get a hearing that are like minor majors. They're not big deal. Then now everyone comes with their lawyers and with their consultants. I think that the proposal envisions that was the role for hearing officers. Like when Liam testified, that he seemed to read it as like everything gets a hearing officer. That's not the intent of the bill. It's, you know, the board would hear the majors where people would really, you know, participate in the process the way I just described. But for those minor majors, a hearing officer could be there, right? And remember that this is all supposed to take place per the legislation in the town where the project is, right? So you'd have a person there, people would show up. I still think there would be an opportunity for the hearing officer to run a proceeding that wasn't, you know, formal and allowed for a back and forth. So that was the idea. There may be other ways to get at that, but that's really where the hearing officer idea of the bill came in. And I should mention, I didn't mention this, you've heard testimony about it, but very important to VNRC was adding in this scoping process. Like this, we've never had that in Act 250. We've talked about it for 20 years, having the pre-application review. One of the reasons we haven't been able to get that is because applicants have objected because they say the process is already too long, and it's already takes them so long to get through the process, they wouldn't agree to another step in the process. And because this proposal streamlines the process, so you get the one hearing, right, rather than district commission, court appeal, Supreme Court, because you're cutting out, you're having the one sort of comprehensive review. You know, I think the business community will agree to have that pre-application process. That's another opportunity that we saw to try to resolve issues even before you get into the process, which doesn't even exist right now. So that's what we were thinking of how it would work. And I don't know if that answers your question.
Yes, it does. Thank you.
John, help me understand. When I was a district commissioner, there was talk of, on the record, and the environmental community did not support that. It seems to me that some of the problems we've identified amongst all the parties, could be solved by on the record. Can you talk about that
Yeah, I mean, I think
at the
that,
district commission level?
yeah, I mean, that's proposal. I looked at, I just looked at yesterday, there was a bill from 2011 that Senator Lyons had introduced that had record review for all the district commissions. And it was actually designed to address some of the issues that I talked about, but the issues that it doesn't address is sort of the capability of those commissions. Like, there's still per diem volunteers in the record review proposals, and they still don't necessarily have the right qualifications. And basically, what I see as a problem with just strict record review is you're just asking the district commissions to do a lot more to actually hold trials, because they have to create a formal record, and it would formalize the process right away.
Except
and-
I just want to
Yeah.
I served on the Middlebury Planning Commission. We were on the record, and it was not particularly formal. And it has been used in the environmental court appeals process.
Yeah, I mean, I think that what I've seen, the municipalities have struggled. I know that they can adopt the Municipal Administrative Procedure Act and have a record review. I think that most towns have struggled with that and creating a record, and oftentimes, I don't know, your town may do it well, but there are a lot of remands because the record was not created correctly, and I think that you would see, a lot of that, certainly a fair amount of that if the district commissions went for record review. But I think fundamentally what you're not doing is you're not getting, you're not paying the district commissions, so you don't get the benefit of having 3 full-time board members, and they don't have the staff. Although I suppose you could say that the NRB would have to staff those, because I think you need lawyer staff to help them through that. And then once you've done that, you've already injected the NRB staff into that process in a way that some people object to this proposal, because that's kind of one of the things I hear, which I understand, that you're losing some of the, one of the things that people like about the district commission is it's totally independent from Montpelier, and that's why district commissions don't, in my experience, like it when the NRB says, hey, can we send our lawyers down to the hearing and sit with you and help you through these issues, because it's their decision and they want to make it. I think with record review, they'd have to have that input, and so you're already sort of joining the district commissions up, at least with the staff of the NRB, and you haven't cracked the nut of what are you paying them, they're not still being paid for their work, and you're asking them to do even more than they were before. If you could pay 9 district commissions throughout the state, then it gets to be a cost issue. I mean, it's true, if you want to invest in the system that way, that would be a way to do it. We never could get support for those sort of investments in the system to actually, pay for the commissions to be more tribunals. But, so those are some of the issues with that. I honestly think that the joint proposal works better, because basically you're paying the 3 people, you're still getting the regional input, and it is creating a record, but you'll be able to create that record, and you'll have more resources to help that along, and you'll have less issues if there are appeals with that issue, with creating the record. So, I mean, that's just my opinion. I'm sure you'll get people with other opinions. There has been some support for those record review bills, but not enough to ever have them, go through, get passed.
My question is why the environmental community hasn't historically supported that.
I think that, I think it's because that it would really change the district commission process, and it still leaves the court in place. I mean, the proposals have been, you're gonna formalize the district commission process, and then you still gotta go to environmental court on the record.
Which would be presumably faster and less expensive, because it's.
It would be faster, but I don't know that the quality of the review. I don't know that. I think we've come around to the point where we just need these fundamental changes in the process, and we think this would be a way to solve it. I don't know if there was a record review proposal now, we would look at it. Maybe we look at it in a little different way, because it would solve some of those problems. But I don't, I'd have to look at the specifics of it. I still think a big issue would be getting qualified people and compensating them fairly and the resources necessary to have record review, throughout the nine districts. I don't know that addresses all the problems that we see today. And I think we see issues today that we didn't necessarily see in 2011, which was the last time that that was the last record review proposal that I saw that got some serious consideration. That was 9 years ago. So I think our thinking has evolved in 9 years on that issue.
Sure.
Good afternoon. Did you look over the commission's recommendation after it ended its meetings? Before the bill that we have now in front of us is
Which commission?
the Act 250 Commission.
The commission
The
on
study, the legislative commission. Can I make it any clearer?
Did we
Act
look?
250 Commission.
Yeah, no, I understand what you're saying
All
now.
right.
Yep.
Did you go through that?
We have, I don't know that we went through it like side by side with talking about the joint proposal.
I'm curious to know if you recognize that there was still issues in that commission that were left unresolved. We couldn't agree.
Yeah, I recognize that.
And one of them was changing the jurisdiction from 248 to 250 when it comes to siting industrial wind turbines. And I'm curious to know if you considered that in your discussion with the administration.
We didn't try to address every single issue. Like I said, we try to come up with a proposal where, from at least our perspective, there was support, and that was not a proposal that we made or that the administration made. And I think we were trying to find a path forward for something that would have a chance to become law. As you know, that's been a really controversial proposal, wherever side of you stand on that issue. And it was not core to Act 250 changes that we were trying to make, which were difficult enough. The criteria, the jurisdictional issues, and we knew that this board, commission, court issue was going to be, it would be controversial, or people would have strong feelings about it. So we didn't try to bite off every single thing, and it just was not anything that either we or the administration asked to be included, and it wasn't on either of our lists.
I would just say that the vote among the 6 commissions was a tie vote, 2-2, 1 abstention, and one of the members was not there. So it seemed to, as it was left on the table, be begging some sort of reconciliation or further study.
I think that if that was going to be considered, it's a big issue. It's an important issue, but it should be its own bill, because I think if that issue is on the table, you will rightfully have people on both, like really wanting to testify and making their arguments vigorously on both sides of that. And I would say that's it's definitely a valid policy proposal, but I would I think it should be its own. I think if you put it into this, whatever Act 250 bill you came up with, if you put it into that, it would just weigh it down to a point where it would be even harder to pass. But I think as its own bill, I think it's fair to have that out. It's just my opinion.
I have one more question.
Yeah.
What would it cost? What is the proposal in terms of having 3 professional board members? What's the cost?
So you have to ask the administration that, because they're the ones who propose the budget and not VNRC. So there is a cost, and I think from our perspective, we were heartened that the administration was willing to invest in a system and pay 3 professional board members. That was a big step, that we had not seen before. Willing to make that sort of investment in the system and add staff. But I can't answer, what the cost is. You should ask the administration.
Representative McCullough.
Again, echoing others in the room, thanks, John, for coming in today, and all the work that you and the administration put together to create the joint proposal. And I want to say that there's much of that I support right off the shelf, as we say. And there's a certain amount that I totally support, maybe with the tweakers here and There's no question, but we've focused today on the board and that discussion, that process that you and the administration kind of went through to come up with the entire thing, but including this board thing. And it's occurred to me throughout the presentations for multiple days, we keep talking about the board, but we do have the existing NRB, the Natural Resources Board, and the joint proposal is talking about an enhanced Natural Resources Board, which we're referring to as the board. And you know, this rustic is trying to keep that parsed out. And when are we talking about the enhanced NRB, and when are we talking about the existing Natural Resources Board? And I think Representative Squirrel has helped me get that straight. But what I guess I want to inquire of today is the discussion about the enhanced Natural Resources Board would have, and the testimony from the administration was about $500,000, give or take, and to fund that operation. And I'm often looking to not create, and I don't say this in a pejorative, bureaucracy, a new bureaucracy, but make what we've got work better. And and this isn't really a what if, because those are dangerous. But the existing Natural Resources Board has a couple of attorneys, yes?
Yep.
And they have staff,
Some staff, yeah.
some staff.
Mostly administrative staff.
Mostly administrative staff. And they have reached out to the district commissions in many ways, education, support, and all, and we've gotten all that testimony. But instead of creating a new enhanced Natural Resources Board, did you and the administration push around the idea of bolstering the existing Natural Resources Board, adding to their mission somewhat, where they shall go to the district commissions and support with staff and attorneys, and keep the district commissions with the increased financial and professional and legal support from the existing NRB?
No, we didn't talk about that. I mean, I think that would be an improvement, you know, in terms of, getting resources to the district commissions. You know, it doesn't address the appeal, you know, the issues that we see with appeals, but, I mean, I think that would be, I mean, I could tell you that, you know, the NRB's been cut. Like when I was NRB chair, it was first, every year, the budget was cut. When I came in, we lost, an attorney position when I was there. And then they lost an attorney position like right before I came there. So they went from 4 attorneys down to, when I got there, to 2 attorneys. And we've always had like 1 enforcement person for the whole state. And that's been part of the problem. I think we do need to fund these systems.
Right.
And we have not funded them properly. So of course, I think that would help. I don't think it would solve all the issues, but it certainly would help.
Yeah. And then did the joint proposers discuss the idea of if then the district commissions did get the type of support they needed to be on the record, how that would affect appeals upstream, and specifically, would they go directly to the Supreme Court in that case, or would they go on the record to the E-court?
Yeah, no, we didn't talk, you know, we really focused on you know, what we came up, what the proposal ended up being was addressing, you know, the problems that we both saw, and we focused a different way. But no, we didn't look at how much that would cost or what that would involve. I mean, there's more than one way to skin a cat. I'm not gonna say that there aren't other ways to solve the problem. I think the verb was one way to solve the problem, but it had a lot of opposition, you know, from the administration, from the business community, from the court system itself, you know. You know, this is a proposal that addressed a lot of those concerns. There are other ways, like what you're talking about. I mean, I think those would things that would help. I don't know how much resources it would take. I think it would take more resources to do it, but I mean, that's a legitimate inquiry. And to my opening statement about, I think there is agreement that these problems exist and that the status quo is not going to work, especially in the long term. But yeah, there are other ways to try to get at those issues, and we didn't talk about those possibilities.
Thank you.
Yeah.
Other questions for John? Thank you.
Well, I appreciate the time, and I mean, I am trying to line up other people to come, if you're going to continue to take testimony on this. I have a few people, some regional planners, and a couple of lawyers who'd be willing to come in and share their perspective with you. They can't come in until next week, though. It's just hard to get people, you know, as you know, scheduling. So if you're open to that, you let me know, and I could
I think we have
give
one-
names to
one
the
more
committees.
question for you.
I have one more,
Oh, I'm
one
sorry.
more question, if that's okay. And you can punt this is not specific to the appellate structure that we're talking about. My question is about, again, referring to some of the testimony we heard last week about the exemptions that were envisioned in this joint proposal for designated neighborhood areas and downtown areas. And my question is regards to the potential for externalities that could occur in a community that may be exempt, say that we went ahead with this new structure. What would be in place to try to, and what I'm thinking of is traffic, for example. If we were to go this route with a joint proposal that had created that, a combination of modifications to it, what would be some of the I think safety nets to ensure that some of the externalities that are currently dealt with on the existing structure would not necessarily occur as a consequence to some of these potential exemptions?
So I mean, I'll answer your question generally, but you should really have Kate McCarthy come in and to talk. She's more the expert on the specifics of this particular issue. But one thing that we did, so already these designation programs, you have to have, this came out I think the first day we presented the bill, you have to have zoning and subdivision bylaws that meet certain standard that the downtown board that issues these designations, you know, that they determine that you've got sufficient safeguards and bylaws at the local level to address, you know, issues that Act 250 addresses. But one thing that we put in the proposal that would be a change is you could appeal. Right now you can't appeal those downtown board decisions, so there are criteria that you need to meet to get these designations that would give you the exemption, and you can't appeal those decisions. You would be able to appeal under the proposal the downtown designation and the neighborhood development area designation as a safeguard, like you're talking about, to make sure that if there's a party that's participating and following the designation proceeding and thinks that the criteria haven't been met and those safeguards don't exist, they could actually appeal those decisions and you know, basically have that backstop. So that's one, we shared that concern and we advocated for that. And that's the change that's in the bill. But Kate could talk about the criteria themselves that are inherently, have safeguards built into them, which I just don't know as much about.
Thank you.
Okay, thank you. All right, committee, so we, been around this issue for a little while now, and just wondering what the committee's thinking about, where you're at. We have to start to think about the big picture and moving this bill, out of our committee, so the Senate can have a chance on it, so with that in mind, I'm curious where people are on this piece of it, on the board, district commission and board structure, after what you've heard. And I'm sorry I missed the Northeast Kingdom this morning. Did some of that relate to this as well, or was it on more?
No.
Okay, good, great. So let's, where are you at? You up for this?
Sure. I would like to pick off where we left off on Friday, and we went around the table and more or less in a straw poll vote said that we favored going forward with the district commission as it was enunciated in our proposal. We were missing 3 members, so we just put it off. It wasn't no formal vote was taken, but I think I've heard enough testimony and evidence that, make me believe that I like to see the district commission go forward. I like the idea of its regional representation. I like the idea that it's more accessible to the public at large. Its 3-member professional board is going to travel around the state. I don't think they're going to get a very fair sense of what these regions, the differences in these regions, and so I'm more prepared now than ever to vote for the district commission.
Other thoughts? Representative Odie.
Well, I'm intrigued with Jim's 2 questions and the bolstering of the NRB and the type of support needed to be on the record. How would that affect the appeals upstream? So I think those 2 things could make the process as it is now better. And no, we don't know the cost, but we can ask for the cost.
Representative Dolan.
I think all of us probably agree with obviously the goals that we're trying to achieve, and it was helpful to hear that there are a number of different approaches. I for one favor the joint proposal, because I think we know that the cost, we already know what that cost is, and while we don't wanna throw the baby out with the bathwater with respect to the district commissions and their great work, we know that if we were to use and continue with that framework, it will be in the structure, it will be a higher cost because of the number of district commissions and the cost to provide the same type of professional, legal, and technical support to those commissions. However, I propose, for the very reasons that Paul identified and the importance of having local input, I support having a 5-member board, three permanent, but the 2 from the region become at par with those existing 3, so that they do more than just findings of fact. They're actually part of the decision making. They're paid for a per diem. There's only a minor, if any, marginal cost for their involvement on that per diem basis. But you're providing that opportunity for greater input while at the same time achieving all the benefits we just heard witnesses describe as to how, what this joint proposal would do in terms of addressing some of the existing limitations. So I would support the existing joint proposal with that modification to it, having the 2 regional become at par with those 3 board members when they hear the majors for their region.
Trevor.
lot of testimony, and I think I said this before, but I've sort of changed my position one day, next day, a couple days after that, moving back and forward. There's probably more people we can hear from. I appreciate that, John. But we've heard a lot already, and I'm sort of landing on the to keep the district commissions and strengthen the district commissions by providing for resources to do on the record work. Again, with the idea of streamlining, hopefully, the appeals process. As far as providing that support, first time I kind of heard Jim say about maybe adding some more resources to the existing structure at the NRB right now. I could go that way. I think it's worth trying, but it's not necessarily a lot different than what your goal is, Carrie, in terms of what you're trying to accomplish. But I think there's a lot of benefit in strengthening and reinforcing the district commissions. That's kind of what I've been hearing.
Representative McCullough.
I too feel that the district commissions are the heart and soul of Act 250 from day one. They represent citizen input. Now, while we're Dylan's rule here in the state of Vermont, and technically the state of Vermont tells the towns what to do, and the towns say when and how fast, we need to understand that with that right comes our responsibility. And our responsibility is to listen to our towns, listen to our citizenry. And I think this room has heard overwhelming support for keeping the district commissions from our citizens. And we've heard strong support for not doing that from central government, if you will, through a bona fide process with VNRC, which I don't mean to be downplaying. Absolutely very important. And you heard me say there's a lot of what's in that joint proposal that I can take right off the shelf and say yes for. This would not be one. I'm agreeing with Paul and Trevor and Carol in saying that instead of throwing the district commissions out with the bathwater, to strengthen them and make them stronger, make them better, make our existing, and then you just kind of heard me like throw that idea out, existing natural resources board stronger and better in the process. And I think if we follow that path, we will also discover how the litigation parts will fall into place and be quicker and less expensive for everybody, which is a goal for all of us, I think. So I think, you know, I'm totally in favor of keeping the district commissions.
Sure.
Nothing to say at the moment.
Okay. Harvey? Chris?
Let's shake the 8-ball.
Any thoughts on?
Well, I have mixed feelings. I agree with Jim on part that it is the heart and soul of the original Act 250, and it was supposed to make it work. It certainly changed and morphed a lot over the years into something a lot more complicated than what I think the original intent was. So I just wanna make sure I understand, all the implications of it before I'm ready. I mean, if it's just on this one particular issue, that could be, but if we're talking about more than that, I really don't understand, totally the appeal process and, the process by which somebody works through the system. I know how the local commissions work basically and the decisions that they make. And I know in our community, we have a lot of, minor projects versus major projects, so maybe we're looking at it differently than something like Chittenden. I don't know. I'd like to take more testimony on it, so.
Impressive.
What-
Representative McCullough, actually, more testimony from who would help you?
Yeah.
Well, I don't know, we heard from, commission members, and, last week, they did pretty good. I see we had some more, information coming in from some of those folks this week, which I haven't had a chance to look at. But how do the people that go through the process view it? You know, how are they impacted with it? What's their feeling on it?
Okay. Representative McCullough.
Well, first to answer at least how one of them felt, we got testimony from Liam Murphy, who, that's primarily his firm's business, is development and development review and representing major developers in major applications. And I think he also said he's represented citizens as well. That I'm not entirely sure about, but I think
Yeah,
he
he
did.
did.
Yes, he did, yeah.
And there are other qualified firms, I'm sure, and people to come in and talk about this concept of keep the district commissions or do something different. But he was very strong, keep the district commissions. And interesting, of course, we know a lot of how law really ends up getting its effect is through precedent. And I think a big part of what he said, we've got 50 years of precedent now, and if we turn this ship around in a totally different area, it'll be another 20 years of building did he say 20?
10.
10
He said for
years.
10
years of trying to build precedent and find our way. So I just bring that out. I mean, that's one very successful law firm who's done millions of dollars worth of business on both sides of issues around Act 250. But what I originally raised my hand for just now was, you know, if that, then what? So if we keep the district commissions and end up strengthening them and end up strengthening the NRB, we have in our draft we have a proposal, and this room remembers lots of testimony. Keep the verb, or do the verb. We love the verb, and keep the E-court. We hate the verb, and we had lots of equally split testimony around that. And in my mind, that goes away if we do what we're talking about doing now, which I think will lead us to another way for appeals. So that could be just a real benefit for us in our decision making. Well, there was a cost thing I wanted to mention too. The administration did say, and on several different occasions, once from Chair Snelling, she may have deferred about the $500,000 a year, actually. But Evan may have said about $500, yeah, that's right, Jim. $500,000 a year-ish. And we didn't really have that totally fleshed out, but there is that willingness to enhance something in this process with $500,000 a year. John Groveman said the administration's got to tell you how much, but I think a different path might cost as much or more. But I mean, we still have no real analysis from anybody about that, so.
So
I like that.
I have a question, maybe for you, Matt. Like, it does seem like the number has been put out there, but it's not been substantiated, or, I mean, where did it come from, and the $500,000?
Sure. For the record, Matt Chapman, General Counsel, Agency of Natural Resources. I mean, there was so the number is out there, and I think it was framed as being a very preliminary cost estimate based on some rough numbers that the Agency of Natural Resources came up with, looking at the existing board structure and also the NRB board structure and also the staffing at the Public Utilities Commission, and trying to make an educated guess about what kind of staffing increases you would need in order to adequately staff a enhanced natural resources board. So I ironically, I was about ready to see whether any additional work had been done. That's what was on my phone doing.
Why don't you keep doing that, and then Evan has something to add.
Very briefly, Evan Meenan from the Natural Resources Board. Matt is absolutely correct. It was a very, very rough number, put together fairly quickly based on the anticipated staffing needs. The hope was that we would convert the current board chair to one of the 3 proposed full-time board members, which would result in 2 additional full-time staff positions, and then 2 new full-time attorneys to basically get us back up to where we were just prior to John Groveman's tenure as the board chair. And then hopefully, but this might be optimistic, redistributing some of our administrative support staff resources, knowing that they would be supporting now a board and coordinators rather than commissions.
Evan, so this gets back to my fogginess about we've got the existing NRB and the enhanced NRB both being called board. Did I hear you say that the chair would be moved to the enhanced board just now? And what does this mean for the existing Natural Resources Board? Is it dissolved and it's now morphed into the enhanced?
When I said that the board chair would be put on the board, what I'm really talking about is the number of positions rather than any individual person. But the way that the joint proposal is structured, the existing Natural Resources Board would cease to exist. It would be replaced by something called the Enhanced Natural Resources Board, or whatever the legislature in its wisdom decides to call it. And it would have 3 full-time positions. Since the existing board has 1 full-time position, that would occupy one of the 3 new positions, resulting in 2 full-time positions that needed to be funded and filled.
Yeah. Thank you. Yeah, that sheds some light here. I don't know what to do with that matter.
Give us $500,000, I guess.
We don't know where that 500,000 comes from.
Yeah. I
Oh, wait,
presume,
Representative Lefebvre, sorry.
Well, I'd just like to get back to the heart of the matter. I'd like to read a quote from Dean Davis. He introduced, was about trying to introduce the Act 250 legislation in January 8th, 1970. And he said, and I quote him, "I hasten to point out that I do not advocate that all decision-making should be concentrated in one agency, in Montpelier. Here is an opportunity for us to apply our creative localism theory, and by utilizing local government, regional planning officials, and development commissions, and a few strategically located district state offices, we will have people located in every region of the state, and they can work directly with developing communities and other individuals to help implement an environmental sensitive central program." And I think that's kind of where I'm at in terms of supporting the district commission, because I think they are the key. I think they are the heart of this whole business, and everything else kind of flows from them. And I think in terms of the public support, I think they earn it more than any professional board that travels around the state. But anyway, I just wanted to get that out there so you can see the original intent when the act was being proposed to the legislature.
Okay, so, Carol.
Oh, thank you for that,
Oh,
Paul.
wait, I'm sorry. Lieutenant Dolan.
Oh,
Last track.
yeah, I appreciate that quote. I one step back when we were still talking about cost. I imagine that some of that $500,000, the source of that would be the savings from the reduction in the number of district commissions. Imagine there's the whole restructured program under the joint proposal envisions, I'm guessing, envisions some cost savings that would then be repurposed.
Well, I don't think the district commissions, I mean, we essentially don't pay them. So I'm not sure where your cost savings is coming from.
Well, we're going down to 9, from 9 to,
I don't think we have 9 now. How many district coordinators do we have now, Evan?
So let's see, 1 and 8 share 1. 3, 6, and 9 are staffed by 2. D4 has 2. I think there's 7 right now, if I'm counting correctly. And the current proposal does not propose changing the number of district coordinators itself, even though it does contemplate restructuring the geography of the commission, the geographic boundaries of the districts. But it's not anticipated that that would result in an actual reduction in number of district coordinators, because they will basically become the commissions issuing minor decisions. So their workload might stay the same or just sort of level off.
thank you, that's helpful.
Representative Smith.
So this raises a question in my mind. This decision that we're making, is this going to change the districts? Because I gotta tell you, it really bothers me to think that Addison County is gonna be rolled into Chittenden County. I think that's an absolutely bad move.
Mm-hmm.
And that would certainly influence my vote. And
Yeah.
some of the other counties might have the same thing. I'm just not familiar with them.
Yeah, I share your feelings about that. Representative Odie.
Well, I was just thinking about the testimony that we heard, and looking big picture, which Paul brought us back to, which is the original intent there. And I thought about the testimony that we heard on a little bit of a different topic, which is people thinking that Act 250 is the problem when it's not really the problem. So the minor application of the restaurant, when they got a minor application approved within 3 weeks for Act 250. But the problem that they had was the historic preservation people and the ANR, who were giving them bad advice. So they ended up spending money and losing time. So what are we going to do to help with that? So we can't.
Whoa, we
but
got
I
enough
know,
on our
but
plates.
basically, you know, just because what people think is the problem, if it's not the problem,
Right.
it's up to us to say, now I've learned what is the problem, what isn't the problem. You know, I have to educate people, but I have to make the decision that seems right to me about what the problem actually is. So to me, the problem can be more solved with what Jim is talking about. I listened to Liam Murphy, I listened to Tom Little, and I'm very persuaded. And then I listened to the person sitting here and realized it's not an Act 250 problem, it's a different problem. So let's see what we can do about that problem.
The Northeast Kingdom person you heard from today.
Yes.
Not John.
No, not John. The Northeast Kingdom problem, which is an Act 250 perception problem. So we have to deal with when we're sitting here at this table, what we learn. To me, this is what I'm just talking to myself. What I learn is the problem, not what is perceived as the problem, and then do the best we can.
Okay, so I'm hearing support for keeping the district commissions, and how could we help them and explore putting them on the record. I would also favor that, I think everyone that we've heard from has been supportive of the pre-hearing meetings happening. And otherwise, it seems to me, you know, John did a good job earlier of outlining some of the problems that we've identified shared problems. One of them is that I think could be resolved by going on the record at the district commission level and supporting that appropriately. We would get to probably the additional attorney staff, which Evan just mentioned, getting that staffing back up to support them. I think we've heard consistently that the environmental court is expensive and can slow things down. I think going to on the record would help with that issue. I guess Ellen, I'm hoping and asking you to pursue language that would help us look at that. Representative Dolan.
I think the other thing we heard was the need for education, or training, and the better relationship, and I don't know how what the language would look like, but a better relationship between the NRB and the district commission level. What we heard was a bit of a Wild West out there occasionally, in terms of not really working well together, and the tension that we heard today in particular, and how can we kind of better support the infrastructure of the Act 250 process. It can only make for better decision making, more consistent decision making. So I just want to mention those two.
Yeah, I think strengthening the board and that relationship needs to be part of this. I've talked with a couple people about ideas about how to do that, and I think we could address that in draft language. I'm also wondering about jurisdictional opinions and how they happen and how that interface happens with the district commissioners, and having that happen more actively with the district commissioners as opposed to maybe it's different district by district, but how much that those decisions are involving the district commissioner. Seems like that's maybe an inconsistency across the state. Ellen, would you want to come up and join us now?
Sure.
So, are you getting clarity from us on this
Yes.
issue? Yeah, okay. Okay, so committee, we need to start moving through other sections of the bill and deciding on the direction we wanna take, essentially section by section. And, I am trying to figure out the best way to do that. We've gotten tables from Ellen. We had thought we would do a walkthrough today of our bill and start doing that, but I'm also open to other proposals for how best to do that. We could do it still high level, things that we are ready to you want high level. So high level would look like what? It would look like having a conversation about the different sections and whether or not the joint proposal addressed it, whether or not we think we are ready to keep it in or take it out, and if we want to do either of those, do we need more information? And do that at the high level as a team sport?
Yes.
Yes.
Okay.
Can we start with this?
Which one is that?
This
Low
is the,
level.
or at least the concepts though are here, the top by topic.
There's something easier than
Are
that.
you,
I'm looking at the side by side comparisons.
I'm thinking about a piece of paper I can't
You were
find.
suggesting 9.2 last meeting.
starting with the base is 9.2, and then probably holding right next to that, a joint proposal, and, weighing, the overall substance, reminding ourselves of why we're doing it perhaps, and, if we have a preference for which language, if both bills address it, which language would we wanna have in it. Hopefully your tables are accessible to you.
Ellen Czajkowski, Office of Legislative Counsel. So yes, I made multiple tables. Okay, Representative Odie just found hers. The high level one with the topics is yellowish.
This
at
is
the top.
nice and high level.
Are you talking about the comparison one or our section by section? The comparison.
It's dated January 16th in the corner.
So Ellen, I have a question for you. Did you present to this committee that list of things that the joint bill did not address?
Yes.
So I have a copy of that if you want.
Yes.
So I think having that out would be helpful.
Is that one that you have there?
Here it is.
It's the same one. Yeah.
Okay, so with that, I have to go to a meeting in 5 minutes. Sorry.
Well,
This one
May not have everything you need.
Yeah.
I'd rather not.
Well, I think that's.
I would rather get over that's what I do. And I would miss your presence here.
I was supposed to dart out at 4.
I'm sorry, I was.
Back in. I just sent a text, I'm not going. But, I would agree.
All right, sorry, committee, we're having a chair, vice chair conference here. I actually have to go at 4 o'clock for a meeting, and so, and usually on Tuesdays, we're done by 4:30. So I guess we are thinking about, maybe everyone should sit here and go through this on their own and figure out where you land, and we can pick it up again tomorrow. I'm sorry about that, but,
Well,
yeah.
yeah. Certainly Paul could lead the room very, very well. He helped lead the room a few minutes ago with being lead-off hitter about district commissions, but I'd really like to have the full head table here,
You're right.
you know, myself.
Very sorry.
And Carol and I were just back and forth about that, and she could weigh in if she wanted to, but I think that's what she said too.
Yeah, I'm kind of saying, oh my gosh.
Yeah, yeah.
Oh my gosh, it's not, we should start fresh in the morning on this.
Yeah.
Right.
Okay, so, everything always works out. Thank you all for your time today and
So
your
we're
explanation of
starting with this.
this. We are starting,
Or one.
well, there's two, I mean, I'm gonna have these three documents out, to be honest, and with the actually language behind, but, we have our bill as a single table. That's the actual language side by side, but we were gonna do high level of our bill with the high level of the comparison. I think that will, we can, and I guess I wanna remind you all, while you're doing your homework tonight, you look at something and say, well, I don't think I have enough information on that, please go back to the record from last year. We took a lot of testimony on all of these. Go back to the commission report, whatever trusted source you have, but please do that. We have taken a lot of testimony on this bill. So before we ask to hear from more witnesses, I think it would be good to consider the witnesses we have heard from over the last 2 years. Representative McCullough.
And this would be an ask from Mark to this afternoon print out that table, which is what we're gonna be working off of, and the high level of the last year version of our bill.
Yes,
Chart,
these two.
those two charts.
And that, yeah.
Mine are in the
I just
same.
handed out all 5 that I made, but if anybody else
He's already
needs
got
one, I'm
some.
happy to make more.
Except
But
they
does
didn't
anybody
find
need
five.
that? Do you need one?
Yeah, this
I
one
do.
is
I
one
need
for
that
our
other,
bill.
I need
Yeah.
that other
Yeah.
one.
1.5
I have
and
this one, I don't
1.16.
need
I got them.
Yeah.
Yeah, here, this is.
I probably got them on mine.
No, that's,
Here's the one for our bill.
this is our bill.
Oh,
There
okay.
you go.
This is the side by side, right?
Here's one for our bill.
Also, 122 is helpful to the
One,
joint
one chart a week
comparison.
I've been doing.
No, I handed them all out. I'm sorry. If it's possible, I'm gonna go make some more. I got one more, but I'm happy to make more copies if we need them. So sorry.
Oh, I think I have.
Sounds like a what?
520.
Take us down.
Oh, oh, we voted that out
Yeah.
already.
We're on to something else.
All right, we
Got
are,
it.
yes.
I
Any other
Oh, you
comments?
told us to take care of the big enchilada, we did.
That's the one.
don't have any more right now.
All right, good.
Okay, we are,
So 115.
we are adjourned.
All right.
We can go off.
No, I'm not 1.5, I'm 1.16.
Correct.
What month is it in Island Pond? So let's see, it's not March, it's not July, it could be August.
It's all here.
Puddles are forming.
Yeah.
I'll be back at 10:30 tomorrow, so
10:30.
10.
So we're all set, so you
Well, you're
don't
gonna
need
hear
more?
from some other friends before
Go ahead and
that.
mix it up.
Got a nice broad array.
Yeah.
Forestry,
Are you gonna be in your office at
I think it just changed.
yes.
It
Okay.
changed.
Are you guys going in and give them the news?
Hi. I have not.
Told you.
Well, the committee is looking to move on from this, and we do want to hear him. Like, hopefully, the hope is that we hear from him
Constituent from the
Thursday.
Northeast Kingdom, we're gonna
Because,
raise beer with.
I mean, unless he's available tomorrow, but that would take a small miracle to make happen at this point. But we've done it before. If you want to, cool. If you don't want to, as long as we hear from him tomorrow and we can try and fit him in on Thursday. I don't want to rush it, you know what I mean? But
He said he was going to get in touch with you, so I don't know if it's a matter of him verifying what his schedule is. I'm going to call him right now. He's at his office, and I can tell you right now I'm going to step out.
thank you. I do agree with this. I do agree with this.
Oh, sure.
I mean, to be honest with you, this, to me, is the wrong direction. We're talking about regional economic development.
Just out of my own
We need to strengthen regions, not combine them.
Consolidate
We
regions.
need to maintain our
Are you going to be here tomorrow?
I won't be.
Do you want to go take a walk to my office? So,
Yeah.
Yeah, thank God, there still is.
Not me.
yes,
Come on,
Rich,
let's
come
see
to
if
my
we talk
office.
to everybody.
I won't make it all the way there.
Give us a glass of
That,
champagne.
that aspect, yes. Excuse me.
All right, you need to be here, you'll be here.
What time we need to be back? It's a 4:30, 4:45. Do you, which, do you,